Good day all and welcome to PUL 342. Today we shall be looking at some interesting topics as usual. I'm Dr. Alero Akujobi, your facilitator for the class. So what are those topics that we have for today on topic 3? The topics are the offenses we shall be looking at are offenses against the state and of course against public order. And under these are offenses like treason. What constitutes treason? When is one said to have committed the offense of treason? We shall be looking at this. Also, we shall be looking at sedition. What is sedition? How does it differ from treason? We shall also be looking at some of the elements that we must look out for in order for the offense to be treason. We shall also be looking at unlawful assembly. What makes up unlawful assembly? When is one deemed to have constituted the offense of unlawful assembly? Also, we shall be looking at riots and also affray. When are these offenses said to have been committed? Particularly, are the elements that are involved? What are those elements that are involved for these offenses to be deemed to have been committed? As usual, it's another interesting class. So please be attentive and welcome on board. Thank you. Hello students, welcome to another interesting day with Criminal Law 342, topic 3, PUL 342. Today we shall be looking at some other interesting topics that has to do with against the state, offenses against the state and public order. And what are these offenses? We shall be looking at treason, what is treason, what is sedition, and what do we mean by unlawful assembly, riot, and affray. So basically, what is treason? Treason basically is a breach of allegiance to one's own government, usually committed through levying war against such government by giving aid or comfort to the enemy. It consists basically of two elements: adherence to the enemy and rendering him or her comfort and aid. So it is deemed necessary for treason to be an offense because it is for the safety of a sovereign nation and its head. It's essential to the existence of a nation. Under Section 1, Subsection 2 of the 1999 Constitution, there is a provision that no person or group of persons should take over the government of Nigeria except under the provisions of the Constitution. Thus, in order to prevent any person or group of persons from waging war against the government of Nigeria or threatening the existence of the nation, certain acts of individuals, such as levying of war, instigating or conspiring to wage war against the government, have been prohibited to be an offense. And that's the offense of treason we are talking about. So at the end of the class, what is expected of you? It's expected that you should be able to know what treason is or treasonable felony, explain the acts that can constitute treason or a conspiracy to it. You should also be able to explain the time limitation for prosecution of the offense, of treason. You should also be able to note what constitutes a different section 38 of the criminal section, actually section 37 to 38 of the criminal code. You will see those acts that can constitute CN. It's important to go through some of these cases, some of these happenings that have happened in the past in order to appreciate what we are talking about. So, is there any time limitation for this? Okay, yes, we have a time limitation for treason. Generally, criminal crimes have no time limitation. They are not statute barred. You can bring a prosecution against any crime at any particular time. But there's an exception in matters of treason. It's important that the prosecution must be commenced within 2 years once the offense is committed, as we find in section 43 of the criminal code. We should also note that the forming of an intention to levy, instigate, or conspire to wage war against the state or the president, as the case may be, and the manifestation of such an intention by an overt act, is treasonable felony and is punishable with imprisonment for life. So treasonable felony is punishable with imprisonment for life as in section 41 of the criminal code, and treason itself is punishable by death. So again, time limitation for prosecution is 2 years. Also note that in the prosecution of the offense of offenses under treason, anybody can be convicted unless he or she pleads guilty to the offense or there's proof of the commission of such offense by two witnesses in open court of at least one overt act of the type of treason or felony charged with or by two witnesses who are witnesses to different overt acts, each of the treason or felony the accused is charged with. This was the scenario in the case of Omisade and the Queen. So you might need to read that. So important thing we should note here is that note what treasonable acts are, note what treasonable felony is, what is the punishment for it, note what treason itself is. Like I've said before, is a case of a breach of allegiance against the state one is from. It could be done within the country, it could be done outside the country, and all of that. And that basically it consists of two elements. That is one, adherence to the enemy, that is rendering him help or aiding him to escape from a particular act. Okay, and also we looked at also some cases like Omisade and the Queen, Boro and R, and so many other and some other cases that federal military government and the and Abiola and Mama Vasa. We also have that of Attorney General of the Federation and Abiola, and so many other cases. So also note that there are we also have certain questions for you here, which are many, but these questions we shall take it towards the end. It is on our slide 9 here, and then we shall look at them towards the end of this course. Again, let's continue by looking at what sedition is. Again, when we are talking about sedition, what is expected of you to know is to know that to describe what it is, to explain what the elements are, and also to state the exception to sedition, explain possible defenses to the offense of sedition. Again, this is another offense that is aimed at protecting public peace by prohibiting any act or conduct which brings or tends to bring hatred or contempt to the person of the president or the governor of the state, or that which excites disaffection amongst them. Note, it is an act of bringing dissatisfaction among the populace, among the public, against the government of the day, or against the administration of justice, or to raise discontent or disaffection among the citizens of the country. You know, again, it can be seen to be communication or agreement which has as its objective the stirring up of treason or certain less commotions. I don't know whether we are following certain less commotion. The important thing is that you must be able to excite the public to such an extent that they have dissatisfaction, you know, amongst themselves against the government of the day. Again, the essence of the offense of sedition is to protect the government against malicious criticisms. You could have some constructive criticism at the same time. Some are also not constructive. Again, sedition could arise as a result of words or by action, by words or by publication, sorry. So generally, it is usually opposed to by the public because of interference with the exercise of free speech by the citizen. In talking about sedition, we should be mindful of Section 39 and 40 of the 1999 Constitution that provide that everyone shall be entitled to freedom of expression, including a freedom to hold opinion and receive and impart ideas and information without interference. So, when a person is convicted for the offense of sedition, what is he? Is jail term normally could be for 3 years, 2 years, or for 3 years, and then such seditious publications, if that's what he used, will be forfeited to the government. What are the provisions of the code that are relevant to this? Within Section 51 of the Section 50, Section 51 of the Criminal Code that covers the situation under which one can be guilty of the offense of sedition. And what are those situations? One, Any person that does or meets or attempts to do any preparation or conspires with any person to do any act with a seditious intention. And mind you, what did you say are seditious intention? Those intentions that are to excite the public, to excite the public against the government of the day without being constructive. Any person that utters any seditious word is also such situation can also give right to the offense of sedition. Any person that prints, that publishes, that offers sale for sales, distributes or reproduces any seditious publication. Also, any person that imports seditious publication can also be liable for the offense of sedition. So, it is also important for us here to know um, that in the offense of sedition, there are certain intentions that must be established. Again, this intention can be found under Section 50, subsection 2 of the Criminal Code. Like I said, to bring into hatred or contempt or to incite against the government of the day, both at the state level or even at the federal level, to incite the citizens or inhabitants of Nigeria to attempt to procure the alteration, otherwise by lawful means, any other matter in Nigeria, or to raise discontent or discomfort among the citizens or other inhabitants of Nigeria, and of course, to promote ill feeling in the government through hate speech, for instance, through doing things that will bring ridicule to the government, through saying things that are not constructive, saying things in bad faith. Of course, all of that is to incite ill feelings among the people against the government of the day. So, once these kind of intentions can be established, of course, those will be seditious intention. We again, for under the penal code, under section 416, seditious intentions are provided for under section 416 of the uh, uh, penal code. Now, if we want, there are certain speeches too that are not regarded as seditious. We should be able to note them. What are these speeches, or what are some of the things that one can do that are not regarded as hate speeches or whatever? Where it is, for instance, to show that the president or the governor of a state has been misled or mistaken in any measure of the federation, as the case may be. For instance, again, you might want to point out errors, defects in the government or constitution of government or whatever. Again, it could be to persuade the citizens of the country to procure by lawful means, any matter within Nigeria. Again, it could also be to point out with a view for their removal any matter which are producing or have tendency to produce feelings of ill will and enmity between different classes of the populace. So that is for sedition. Now, the Supreme Court again in DPP and OB have stated that where it confirms the right of every citizen to fairly criticize or censure the activities of government, including public policy, as long as this is done in a malign manner, in a way that public peace cannot be affected. Take note of that because it's Supreme Court's decision. That's the case of DPP and OB, where Ademola CJ of the CJ of the country of the Supreme of the highest court of the land then was saying that provided the critique is done in good faith, including to censure fairly the activities of government and done in such a way that it is not malign in any manner and it does not bring about breach of the peace. Of course, it will not be seditious in any way. Again, we also have to realize again that among some of the cases that have come before the Nigerian court, publications accusing the government of a regime of abuse of office, misuse of public funds, for instance, have been declared to be seditious, as in the case of African Press Limited and Attorney General of the Federation. Again, seditious intention can be inferred from the manner in which it is done. The essential element is that the words used must have the tendency to excite, like I've said earlier on. Okay, so we also see that Section 50, subsection 3 is essential in inferring seditious tendencies. We also see the case of, it is also important to note that the intention to incite should be required under the criminal code and not merely deeming a person to intend the consequences which would naturally flow from that. So, what are some of the defenses to a charge of sedition? We need to know that the truth of an alleged seditious word or publication may sometimes amount to a difference in the charge of sedition, especially in showing that the intention of the accused relate to the exceptions as under section 50, subsection 2. So, generally, once the prosecution has proved seditious intention, it is not a defense on the part of the accused that the words or publication alleged as seditious are true, as we saw in that other cases. So, the testimony of one witness. So, in summary, sedition principally is an offense of exciting feelings of dissatisfaction against the person of the president. To fairly criticize the activities or measures of government in order to obtain alteration by lawful means and without citing a feeling of disaffection, that of course will not amount to an offense. Important sections to note are section 50, subsection 1, subsection 2, subsection 3. Also important to know that it is freedom of expression and the offense, of course, cannot supersede the provisions of the Constitution. Again, it does not stop you from expressing sedition, from expressing your feelings or whatever. But what is expected of you is to come about with constructive criticism that do not excite the public against the government. So, some of the questions, I also have some questions here on sedition. The other time we had some questions on treason. I hope you can go back there to look at it. The questions on seditions we have here is, for instance, in order for words to amount to sedition, is it necessary the alleged seditious word should intend to incite to violence? Will the position be different if the words used are inciting, but the audience are not moved to violence? Again, some audience are of educated persons, some audience are of, let's use the word, reasonable persons. Would it matter if the audience is consisting of that the audience are not worried or they do not they are mindful of such speeches and all that? What is the position of the law? Okay, again, like I said, go through your section 50, subsection 2 and subsection 3 in order to answer this question. What is the period within which the prosecution for sedition offense must be commenced? We stated this too. Please go back and read. Again, what are seditious intentions? See that in your section 50, subsection 2. Finally, you should mention 3 acts, speech or publication that will amount to sedition. I'm sure by the time you are able to answer all these questions, go through all of this, you'll be able to fully beat your chest that you can say 1 or 2 things on the offense of sedition. Thank you for your time.